Get ready, start. Under Article 298 of the Constitution, and executive power of the Union and the state shall extend to the carrying on of any trade and to the acquisition, holding, and disposal of property and making of contracts for any purpose. The state can carry on executive function by making a law or without making a law. The exercise of such powers and functions in trade by the state is subject to Part 3 of the Constitution. Article 14 speaks of equality before the law and equal protection of the laws. Equality of opportunity should apply to matters of public contracts. The state has the right to trade. The state has there the duty to observe equality. An ordinary individual can choose not to deal with any person. The government cannot choose to exclude persons by discrimination. The order of blacklisting has the effect of depriving a person of equality of opportunity in the matter of public contract. A person who is on the approved list is unable to enter into advantageous relations with the government because of the order of blacklisting. A person who has been dealing with the government in the matter of sale and purchase of materials has a legitimate interest or expectation. When the state acts to the prejudice of a person, it has to be supported by legality. Blacklisting has the effect of preventing a person from the privilege and advantage of entering into lawful relationship with the government for purposes of gains. The fact that a disability is created by the order of blacklisting indicates that the relevant authority is to have an objective satisfaction. Fundamentals of fair play require that the person concerned should be given an opportunity to represent his case before he is put on the blacklist. Again, in the case of Raghunath Thakur versus State of Bihar, 1989, 1 SCC 229, the aforesaid principles was reiterated in the following manner. But it is an implied principle of the rule of law that any order having civil consequence should be passed only after following the principles of natural justice. It has to be realized that blacklisting any person in respect of business ventures has civil consequence for the future business of the person concerned in any event. If the rules do not express so, it is an elementary principle of natural justice that parties affected by any order should have right of being heard and making representations against the order. In that view of the matter, the last portion of the order, insofar as it directs blacklisting of the appellant in respect of future contracts, cannot be sustained in law. Thus, there is no dispute about the requirement of serving show cause notice. We may also hasten to add that once the show cause notice is given and opportunity to reply to the show cause notice is afforded, it is not even necessary to give an oral hearing. The High Court has rightly repudiated the appellant's attempt in finding fault with the impugned order on this ground. Such a contention was specifically repelled in Patel Engineering Patel Engineering Limited versus Union of India 2012 11 SCC 257 2013 1 SCC Civil 445 bracket closed. In the case of Messrs. Mahabir Auto Stores and others versus Indian Oil Corporation Limited 1993 SCC 752, it was held by the Supreme Court that arbitrariness and discrimination in every matter is subject to judicial review. Paragraph 11 of the aforesaid judgment is quoted below. It is well settled that every action of the state or an instrumentality of the state in exercise of its executive power must be informed by reason. In appropriate cases, actions uninformed by reason may be questioned as arbitrary in proceedings under Article 226 or Article 32 of the Constitution. Reliance in this connection may be placed on the observations of this court in Messrs. Radha Krishna Agarwal and others versus State of Bihar and others 1977 3 SCC 457. It appears to us at the outset that in the facts and circumstances of the case, the respondent company IOC is an organ of the state or an instrumentality of the state as contemplated under Article 12 of the Constitution. The state acts in its executive power under Article 298 of the Constitution is entering or not entering in contracts with individual parties. Article 14 of the Constitution would be applicable to those exercises of power. Therefore, the action of state organ under Article 14 can be checked. Messrs. Radha Krishna Agarwal versus State of Bihar Supra at P.462, but Article 14 of the Constitution cannot and has not been construed as a charter for judicial review of state action after the contract has been entered into to call upon the state to account for its actions in its manifold activities by stating reasons for such actions. In a situation of this nature, certain activities of the respondent company which constituted a state under Article 12 of the Constitution may be, in certain circumstances, subject to Article 14 of the Constitution in entering or not entering into contracts and must be reasonable and taken only upon lawful and relevant consideration. It depends upon facts and circumstances of a particular transaction whether heating is necessary and reasons have to be stated. Stop.